Bridget.
Hello.
Hello, hello. Well, I believe we can start right on time. I think this event is going to be recorded by the organizers, the Houston Bar Association International Law Section. And we are using the Zoom from Beck and Redden through our president and chair of the International Law Section, Mr. Sipan Persigian, who is also joining us in this event. With that said, I welcome everyone. Thank you for coming. Thank you for registering. Thank you for attending. And this is going to be what I hope a fun and informative event for everyone. Today we will discuss the issues of corruption, particularly corruption in Latin America. As you all well know, corruption affects, it's a cancer really that affects society in every way. Since I can remember my childhood years in Peru, where I grew up, the people in Peru always complain about corruption. And the same has been the case for many of the countries in Latin America. And people even said it doesn't matter if the politicians steal money as long as they do something. And it's a really terrible situation in which we are faced with a choice between having a politician stealing as long as they do something for the country. As you all know, corruption is a very destructive force. It even affects democracy by undermining the elections and elected officials. Distrust creates distrust, and it causes, in reality, it causes the erosion of the institutions and the rule of law in general. On the other hand, countries have been fighting corruption for as long as we all have been alive, and the efforts to fight corruption in Latin America don't seem to be working very well. Corruption in Latin America continues to be a big problem, and Latin America is one of the hotbeds of corruption in the world. So based on that background, what we are going to do today between the three panelists that we have here, the three experts that we have here today, is that we're going to discuss what can a multinational corporation do to survive and be competitive in this environment. What can they do? What can they look for? What will be the outlook for the future? And in general, what can we do in order to make the situation better? As I said, we have three fantastic experts on the topic, and I will introduce them, starting from Bridget, our lady in the panel. Bridget is a partner of Steptoe in Washington. She has practiced in business disputes and conflict litigation and internal investigations and global anti-corruption issues for several years. In her practice, she conducts internal investigations relating to a variety of sensitive and business critical issues, such as the FCPA, financial fraud and corruption, employee misconduct, ethics, codes of conduct, violations, accounting irregularities, and whistleblower complaints. I am going to ask everyone to please mute your microphones. She has also been the president of the DC Bar and serves as an adjunct professor in Georgetown University. She has received several accolades from many institutions and magazines and different journals. And from her education, she's a JD from Boston College and a BS from the University of Florida. Next, we have Marlon Paz. He's a partner of Mayer Brown, where he leads the broker-dealer regulation and compliance practice. Marlon is an expert in financial regulation and corruption related to financial regulations. Marlon served as a principal of integrity officer of the Inter-American Development Bank, where he led the team of lawyers and investigators in the development, investigation, and prosecution of fraud and corruption cases. He also oversaw compliance procedures relating to issues such as integrity, due diligence, anti-money laundering, offshore financial centers, and has been recognized also by multiple institutions and magazines as a leading authority in the topic. He was also past president of the Hispanic Bar Association of DC, and he is a JD from the University of Pittsburgh, LLM from Georgetown, and MA from Wesleyan. Oh, BA from Trinity. Last but not least, Pablo Gil de Montes, who is managing director and head of the Latin American practice at Gryphon Strategies. Pablo has extensive experience working on managing all strategies of this discovery in multi-jurisdictional and investigating matters involving financial fraud, bribery, corruption, and antitrust. He has conducted anti-corruption engagements and investigations throughout the world. He's an expert in compliance, accounting, data analytics, and interviewing. He also has several years of experience involving managed review teams creating defensible strategies to minimize costs and reduce corruption in corporate entities. Pablo holds a JD and an LLM from the University of Pittsburgh and a BLL and a law degree from the University of Lima, where we were classmates. Since he was last, I will start with Pablo with a quick question. Very broad too. Why, in your view, is corruption so prevalent in Latin America?
Well, first, let's start with what is due. Thank you, Rafa. Thank you to CPAN, and thank you for everyone to connect to this webinar. I know we always seem to, there's an influx of webinars, and I'm pretty sure you're gonna have fun on this one. We're not gonna put you to sleep for sure. And I'm very honored to be a panelist with my friends and colleagues, Bridget and Marlon. They're two of the most experienced people in this thing. The question is very interesting. Why Latin America, right? You know, when we talk about corruption, we understand that corruption is a human risk. Okay, it's as human as possible, because if you think about the first corruption case ever is Adam and Eve, right? And the apple, right? That's something that basically, it's ingrained in our humanity, right? Latin America is a different thing, and I always a little bit about me and background. This is why I'm, as you, I grew up in Peru, but I come from Spaniard parents, so I always had growing up, this thing about comparing why corruption is the norm here and why corruption is exception in other places. So I've been studying this for a long time, and I came to the conclusion that it comes from the original sin, what I call the original sin. and I'll explain why. To the US, a group of pilgrims came with a one-way ticket and with the only purpose of creating something. They knew they were here for the long term. On the other hand, in Latin America, the conquistadors arrived there with a two-way ticket, with their only purpose of, finding personal benefit. So the only way I can see this is that idea of personal benefit, it's ingrained in our societies in Latin America, and that's why there's no real concept of society, of how, that's how it was so generalized, because at the end of the day, it's all me, my personal benefit, and that. So at the end, at Gryphon, we always say that, it's a human risk, but it requires human solutions. As consultants, we can do great PowerPoints on that, but if you don't take care of the human part of the corruption component, is very, very interesting. Another issue with corruption is that, it's a relative concept. In every single country, it means something different. It depends on each society's values. So what in China, it's something that a gift could be, it's something normal, it's a blat, it's something that is there in society, has been went from generation to generation. It's viewed in the eyes of a U.S. regulator as a potential bribe to get something, right? I usually utilize two examples when trying to figure out how we can fix Latin America, right? And I'm always, I always see, and I usually, talk about two countries, Hong Kong and Singapore. Hong Kong and Singapore were two of the countries with the most amount of corruptions in the 50s and the 60s. They were very corrupt places. And what happened is that in these days, the anti-corruption efforts are paying. And when talking about that, I'll give a good example, because Lee Kuan, who's the founder of corruption, always thought that the rule of law and then having a very strict penalties for corruption was the only way to go around. And there was this interesting thing in where two economists named Fisman and Miguel actually tried to prove Lee Kuan wrong and said, we're going to analyze and we're going to do a social experiment, and we're going to check whether, this is coming from behavior, corruption is coming from human behavior, or, coming from cultural background, right? So what they did is they analyzed 5 years of unpaid parking tickets in the city of New York by foreign diplomats who worked in the United Nations. So what they realized that, as you know, if you're a foreign diplomat and you get a parking ticket, you don't have to pay it, right? But they realized that when we're trying to figure out whether this is something that is a societal thing, or is it something that comes from penalties or behavior, they realized that, there were some countries that had diplomats from some countries that had 0 parking tickets, where other diplomats for other countries had many parking tickets. For example, there was a Kuwaiti diplomat that had 526 unpaid parking tickets, while the Norwegian diplomats had 0. So what they concluded is that corruption tends to be high, in those, where they saw the societies were corrupted societies, the parking tickets were basically, accumulating, right? Or the unpaid parking tickets. But when they were more advanced and with a more, with less corrupt societies, those parking tickets were minimum. And
so forgive me for interrupting you, but it seems like you're saying that the rule of law in the countries where corruption is more prevalent has something to do with a cultural impact on how to fight it as well, right? And in Latin America, we have had like many efforts to fight corruption, and very little success has come from those efforts. So Why, in your opinion, are these efforts not successful?
Well, because of our past, right? We're always dealing with, with past leaders and people that come into power in the political spectrum. When someone comes into power and wants to persecute the other one, and they want to look for one way or not the other one. Then the other thing that we encounter a lot is that there are no long-term goals for as country, as policy, right? They everyone, we can, every time we talk about Latin America and, governments trying to change corruption in Latin America, you're talking about reforms. But, in my opinion, it's not about reforms, it's about sustained changes. If you don't have sustained changes, you're not going to be able to change anything. And another point is an interesting point of why you think, these efforts are not working. It's because we have in Latin America weak institutions. We went to law school together in Universidad de Lima. I remember there was only one person who wanted to be a judge. One person, the whole class. When I studied law all over again here, I think 40 to 45% of class wanted to be law clerks, or so that's what changes here. When people don't realize that, at the end of the day, the cliche of we need to be reinforcing institutions. How do you reinforce institutions? You reinforce institutions, by humans reinforce institutions. So they have to realize that. And, basically, to answer your question, I think that what has happened in Latin America right now is that in order for any country to have a successful anti-corruption policy, they need to follow three avenues. One is the investigation avenue, the other one is the prevention avenue, and the other one is the education avenue. Many countries are focused on investigation only, but they're not educating and not preventing. And that's basically how I see it, and that's why I think if there's not a political and a real thirst to be able to do this, we're not going to be able to accomplish those things.
Let me jump to Bridget for a minute. Bridget, obviously, Pablo's talking about investigation, education, and what was the third one, Pablo?
So it's investigation, prevention, and education.
Prevention.
Yeah.
Sorry, prevention. So how is the U.S. trying to work with the Latin American countries on those three fronts? Normally, what I would assume is that they are only focused on investigation more than prevention and education.
There's actually been, it's a good question. And frankly, in my own practice, while I do some prevention and some education, I tend to come in when there's been a problem. So, I usually come in at the investigation phase, to fix something that's gone wrong. But in terms of the US, there have been partnerships in the last, I would say it's been growing in the last 5 to 7 years, where it used to be just a focus on investigations and enforcement, essentially, but there has been partnerships between prosecutors here. DOJ has sent prosecutors to various places in Latin America. They've done it in Brazil. They've done it in Argentina, to actually work with them, not just on improving their investigations techniques, but also in thinking about what they can be doing, from an education perspective.
Okay, so from your view, the DOJ is actually, or other institutions in the U.S. are actually working more than in just the CPA enforcement and putting people in jail and fining companies, which is the side that I normally worry about.
Well, and ultimately that is their main objective, but I think that there has been an increase in education and in training. And certainly we've been doing it, maybe not through DOJ, but I think because of the FCPA enforcement, a lot of lawyers like myself, outside counsel are working with their clients all over Latin America in order to focus on prevention and education, so that they don't get to an investigation phase. So there's been a lot of that. And I think that there's, the same way we saw it here in the US when, 20 years ago, I remember doing some FCPA investigations when there was hardly any enforcement, and companies would say, what, a policy? Yeah, sure. Wait, hold on. Let me look here in the drawer. And now that's not true, I think, but multinational companies doing business all over the world, including doing business in Latin America, are now much more advanced in that and have not just policies and procedures, but, regular training and updates of their policies, audits, all of that.
So you just mentioned the trifecta of policy training and audit, and that help us to some extent not get in trouble with the DOJ. But who else should we be worried about in terms of enforcement and compliance? Is there anyone else that is doing something in terms of sanctioning or investigating?
Well, absolutely. And I think that one of the greatest risks that multinational companies face today is that it no longer is just a question of DOJ, SEC, compliance and enforcement. There are now, everywhere you look and everywhere you are involved in, and have operations can potentially be, an audience that you have to be thinking about. And so certainly DOJ and SEC have worked with a lot of national authorities, and we've seen that in the cases, in the last few years where there's a growing collaboration and information sharing. And so I think companies need to be aware of those. But then there are also institutions like the international financial institutions, like the World Bank, the Inter-American Development Bank, the Asian Development Bank. All of these institutions have established investigative and sanctioning mechanisms. And the rules are not what we're used to with typical government investigations, and the process is quite different. But the results can be very costly for multinational companies doing business with or doing business on anything financed by these institutions. So there's often a debarment. There can be fines or parallel investigations. I'll give you an example. Right now in Chile, there's a huge scandal over a company called Itelecom regarding a $18 million contract to improve public roads, public road lights, actually, to apparently to LED high efficiency technology. And in all these municipalities, and it's financed by the Inter-American Development Bank. And so the company has been, and individuals in the company have been prosecuted by the national authorities, but now there's a follow-on IDB investigation, and that can ultimately have an impact on the business, because what happens and the way it works is a lot of these institutions require contractual compliance with ethical standards, and they put it in the contract. So there's an audit clause that gives them the right to, come in and essentially conduct an investigation. And, people are subject to these contractual obligations. They may be bidders on a contract financed by one of the institutions. They might be a supplier on a direct procurement contract. They may be subcontractors, consultants, sub-consultants. I mean, you could be working on a project financed by the World Bank, and you've never been in the same room with someone from the World Bank, but those obligations apply to you, you as a person and you as a company. And so, that can lead to an investigation where right now, all of these institutions work together, they share information, they sanction companies. It's a very low standard of proof. So we're not talking DOJ and a criminal standard. We're not even talking, frankly, SEC and a typical civil standard. It's a more probable than not, but enforced in it's an administrative proceeding, but the consequences are pretty serious, because when a debarment is public, it means you can't do business with that institution. say the World Bank. If it's over a year, you're automatically barred from doing business with a number of other institutions that have all agreed to recognize the debarments, of their peers. But then what happens is, because it's public, it gets picked up by due diligence, things like Roll Check and LexisNexis and all of these. So you are and your company is automatically on a blacklist for fraud or corruption or whatever it is, when it sounds very, very serious, but often the cases are very different than what you're seeing on FCPA cases. They're much simpler type cases, but the consequences are pretty serious. So it's something that's important. Many companies don't appreciate the exposure or the risk. So it's important to keep that in mind.
Well, Marlon, in that context, very difficult environment, what steps should a company consider in determining whether they can contract with one of these entities, or hire a local representative, or pay a third party in a local jurisdiction?
Very good questions, Rafael. First of all, thank you for the invitation to join you here. Hoping the audio is coming through well. It's always a pleasure to collaborate with Bridget and Pablo. And so let me take a stab at that. Appreciating the intellectual presentation of Pablo, can I take a pop detour here? Bear with me for one moment. This is
we're trying to get grounded here.
I like that, and
I'm trying to give you guys concept, guys. Come on, you gotta step behind.
Well, I'm not able to share my screen, otherwise you guys would see a small clip. But if I were able to share my screen, I would show you a clip from the movie Syriana, which discusses the concept of corruption. So maybe if later on in the program, if someone's able to turn on my ability to share screen. My jumping off point, because I'm a U.S. lawyer, albeit one that was born in Latin America. I was born in Honduras and did not come to the U.S. until later. My point of view, my professional life has been in the U.S., and the concept of corruption is one that we are very, very finely tuned and aware of. In fact, my career has been in dealing with fraud or corruption in the United States. So it is not a foreign concept or endemic elsewhere. It's very much at home here. And for those of you aficionados that have been seeing our elections go through, and the upheaval here in Washington, D.C., you know that is not new. In my professional career now, I am helping and assisting primarily financial institutions on coping with and dealing with the intricacies of multinational commerce. Your question is very apropos to that. What can a company do to protect itself? In number one, dealing with such commerce, which inevitably will involve third parties or others in Latin America. If you are doing work in Latin America, if you're building a road in Latin America, you may get the cement from somebody there. I don't know, Mexico, just to throw out a country.
And we have to consider the buy local regulations that obligate us to do that.
Exactly. There may be some country level issues, but at the time of payment, the risk that corruption will have a direct impact on your transaction, and to put it in monetary terms, will have a direct impact on your return on investments, is most acute at the time of processing payments. But your ability to process that payment has to begin long before that. So before stepping foot, take heed of again, I will reference the intellectual presentation that Pablo presented. He has loads of information, and it is fantastic to get someone like Pablo who's got, the underground intel, who kind of got his ear to the ground. I phone him and I say, hey man, who's going to be the next president of X country? Because he knows. I don't know how he knows, but he knows. So I have no idea. I have a hard time keeping up with Washington. So the point is due diligence on those providers, those third parties, those contractors, those local agents is essential long before you ever get to the point of being obligated through a contract to pay. And I'll give you an example. When I was in-house, we dealt with a situation in which we were contractually obligated to pay someone that was on the OFAC list. And therefore, we could not get a single bank in the US, and all of our accounts were in the US, to be a correspondent bank to be able to pay that individual. By the time you get to that point, that is a very difficult problem to have. But if you're a company and you're at the inception of that, you're masterminding, you're dealing, you're the CFO, and you're thinking through, if we win that bid, if we are awarded that project, if we're going to build that road, that bridge, put in those mainframe computers, whatever you're working on, it's at that point that you need to start thinking through, how will the flow of funds work? And which institutions are going to help me do that, so that you don't end up, for example, being contractually obligated to pay a party that in fact is not someone you can or should pay without being out of compliance with either US law or the laws of many other countries that now have their own anti-corruption regimes. More on that later, but I think in answer to your question, it is profoundly important to do that due diligence so you know who your counterparties are, who your third parties are, who your employees are, before you can process those payments or that flow of funds at the time of payment.
All right, so due diligence is the key on the ground, but to many people, due diligence is I mean, and even attorneys and compliance professionals, due diligence is very difficult. It's very hard. What can you do to get that person or that entity that you're going to be working with down in Latin America to share the necessary information or to comply with your programs? The only hook that I can think of is money, but you may have other ideas.
Well, money is one, certainly a very powerful indicator. Again, by the time I step in, I'm advising a lot of the financial services companies that are trying to process a payment or effect a payment. I largely work with banks and advise them. Someone like Bridget works a lot with the companies themselves.
Right.
But what I would say is the companies that have been smart about it have worked with someone like Pablo ab initio to understand and get intel and know those third parties. Has that party been perhaps one of the central figures in Lava Jato? He'll know that sort of thing, and that's a service, and that kind of intelligence is available. Now, if you understand that, then you need to make a determination. Do I get involved in this project if I must do so with this other person as part of my consortium or part of my joint venture? And I got to tell you, the price is almost always too high to pay. So it'll cost you way too much in the end in reputational harm, reputational risk. The issue here is that you have the power to be involved or not. And that's not just the money in the end. That's the ongoing due diligence that you will condition it. You will condition the payment on ongoing compliance. But at the front end, if you demonstrate that you have conducted and you have a program for conducting due diligence, knowing who you're in bed with, that's going to be essential. To use the vernacular, and I like invoking my grandmother, dime con quién andas, y te diré que. And yeah. It couldn't be more true in this situation. Tell me, tell me who you're with, and that'll be a high reflection of who you are. So that is something you can do. That's beyond money. That's beyond the payment. That's beyond the carrot. That is, who are you coming to the party with? And that's going to be a very great indication of your involvement or non-involvement in a potentially messy situation in a particular country.
Thank you, Marlon.
Rafael, if I can
Yes,
add to
absolutely.
that, I completely agree with Marlon. And I think from a company's perspective, I mean, you know, there's a lot that you could do with third parties, right? To incentivize them and to encourage them, you know, to comply and to find out all the information. And I think we know all those things, and you put in, you know, you make them sign a certification and you make them go through training. And, you know, I think probably folks on this call know about all of that. And you could do that. But I think that the other side of the coin is, you know, what the company itself does. So you can only do so much to control a third party. You can find out about them, you can incentivize them and encourage them to comply. But ultimately, your best weapon, your best tool, I'm a litigator, so I think in terms of weapons, but that's not right. But your best tool is to, you know, to make sure your house is in order first, right? And so you need to make sure that your folks in Latin America, you know, because that's where we're talking about today, but anywhere, that they are, you know, on board, that they have been adequately incentivized, that they have been trained, that, you know, that the company from top to bottom is doing all of the right things, that there's, you know, updates on the, you know, on the programs. All of that, I think, makes it also easier, you know, for people to feel comfortable following those policies and procedures when it comes to then, you know, hiring third parties or resisting, because what I see a lot is resisting the hiring of, you know, say fulanito, you know, so-and-so, because they're the cousin of the this and that, boy, that takes you down. You know, sometimes you have no choice in smaller countries, but you know, it makes it easier if people are comfortable that they're going to be supported, that compliance is, you know, is a priority. It's, you know, emphasized from top to bottom. Someone will have their back if they make the right call.
Yeah, that is an interesting point. Pablo, yeah, I was going to go back.
I just want to add something here, which is,
yes,
you know, which is kind of from the experience dealing with a lot of Latin American companies. You know, I tend, even when I speak Spanish, I tend to use the word compliance instead of the Spanish word cumplimiento. Because, you know, it reminds me when, you know, when my mother, you know, used to get upset with me when she used to take me to mass, and, you know, she would tell me, you know, you're not paying attention to the priest. You're doing this for cumplir, saying, you know, to be able to comply, right? But then at the end, miento, to lie, right? So cumplimiento, not compliance, right? So basically, what I've seen a lot in Latin America right now, and this is something, you know, that I'm trying to share with your colleagues, is, you know, there's a lot of companies out there that, you know, and unfortunately are doing compliance just to comply, just to check the box, right? And, you know, and many times when you're dealing with those companies, you have to have that into consideration, and you have to understand that, you know, is this a real compliance? Is this something done in an honest way, and, you know, with a total, let's get religious here, a total examination of conscience, right?
Okay, so I was going to go back to you anyway, and I want you to add to what you just said.
Okay.
So we're doing an examination of conscience right now, and and Marlon mentioned Lavallato, which was a like you know, a high water moment in corruption in Latin America, specifically in Brazil, but it involved every other country in Latin America.
Rafael, if I may rudely interrupt for just one brief moment of levity here before we get back to Professor and his intellectual discourse on corruption.
Hey, Marlon, sorry to interrupt you while you're interrupting me, but I think you're going to start calling me a nerd now. I don't know, but go ahead.
Oh, we have the video. Good.
Corruption is government intrusion into market efficiencies in the form of regulation. That's Milton Friedman. He got a goddamn Nobel Prize. We have laws against it precisely so we can get away with it. Corruption keeps us safe and warm. Corruption is why you and I are prancing around in here instead of fighting over Corruption is why we win.
There you go,
I
my
guess-
friend.
Corruption is
I
why
guess
we
Is
win.
why we win.
Yeah.
Okay, Milton Friedman. Okay, professor, have at it.
All right. So, Rafael, he got to finish us answer the question.
Yeah, no.
Right?
So Lavallato, that they were winning. Odebrecht was winning, you know,
Yeah.
but then all of a sudden they stopped winning. What I mean, what happened? And of course, I want you to talk a little bit about, Professor, about a little bit of what happened before and after Lavallato, because the world in which we live in could be kind of separated by that line.
Yeah. So, thank you, Marlon, again for calling me a nerd. I am a nerd.
And I have the books behind me.
Yeah. Well. Yeah. So, so yes, you're right, Rafael. You know, it's Latin America could be divided from before Lavallato and after Lavallato, right? Because that is you know, that's what triggered everything. Before you know, we used to go to Latin America and talk about FCPA and talk about corruption. People used to see us as, you know, Martians. I remember people introducing us like the future, you know, because I was going to talk about FCPA. And they didn't realize that that was something that it was coming, right? So, you know, what triggered Lavallato, you know, is and why Brazil, right? Why is that happened in Brazil? And I have to go back to the 1988 Constitution of Brazil, the Federal Republic of Brazil, as opposed to other countries. You know, that Constitution in 1988 ensures that lifetime appointment of judges, okay, and prosecutors. And basically what they do is they shield their shielded their budgets from politicians, right? So when you have that, and it's well known, the judges in Brazil are people that, you know, there are, you know, impeccable reputation, people that, you know, are well off. You know, remember the Lavallato judge that I was investigating, he was flying on his own private plane and the plane came down mysteriously, right? So that is what happened. You know, what happened is that there was an idea, and then added that in 2000s, there was a, you know, the OECD, you know, they joined the convention of OECD, and then in 2010, they did what the Ficha Limpia law, which is basically, you know, giving criminal convictions to officials and to and you know, if you were convicted, you know, you were disqualified from running from office for 8 years, right? So that is what changed. That's why we're talking about Lavallato, right? And you know, unfortunately, Lavallato now is ending, and he's ending because he was stained by political aspects, right? You know, Sergio Moro became more of a, you know, a political pawn there. So again, going back to the problems why Latin America, you know, is not successful in their anti-corruption efforts, is because, you know, politics is involved, and you know, there's no long-term approach. But Brazil is the closest thing, and Lavallato is the closest thing to a great step and a great effort.
Okay, enough with the past. Yes, Bridget, please.
Actually, not so much of the past, but at one point on the post-Lavallato world, because it continues to give rise to U.S. corporate enforcement activity. So if you look at, you know, FCPA enforcement last year in 2020, of the 12 enforcement actions brought against corporations, right, 3 involved allegations of bribery of executives of Petrobras, of Brazil's state-controlled oil company. And so, you know, there's still a continued focus on Brazil. And one other thing to tie it to, since I know many folks are in Houston, one of those 3 was the Vitol case, Vitol Inc., which came right at the end of 2020. There was a particularly interesting case. It's a, you know, a Houston-based U.S. affiliate of one of the largest energy trading firms in the world. And Vitol entered into a DPA with the Department of Justice in relation to payment of bribes to government officials in Brazil, but also in Ecuador and Mexico, in order to get contracts. DOJ charged Vitol with 2 counts of conspiracy to violate the anti-bribery provisions of the FCPA. And what makes it, and they had to pay a combined $135 million to resolve those investigations, and then the parallel investigation in Brazil. But what's really interesting is in another investigation, because we're talking about other institutions, right? Now there's multiple regulators involved. The CFTC, the Commodity Futures Trading Commission, also settled charges against Vitol, requiring it to pay an additional $28.7 million to the CFTC. And that was the first ever CFTC enforcement action involving foreign corruption. So we're still seeing a lot of activity, and a lot of focus on Brazil vis-a-vis the US.
And, let me add something to what Bridget said. And Bridget, that's what's going to happen is, I'm saying Lava Jato has not ended. Lava Jato is here. What is going to happen is the ripple effect of Lava Jato is going to affect several countries in Latin America. It's just starting. I think we're going to talk a little bit about what's the future, but we're going to see that happening, right?
It's been 7 years, and we will continue to see the ripple effect, huh?
Yeah, we're still dealing with RMBS, 2008 issues. Still, the investigation is still going on. So that's something that's going to go for years.
Marlon, one quick question. You're a finance expert in the team. So how is all this environment affecting project finance down in Latin America? And aside from the World Bank, which Bridget mentioned, and the Futures Association that Bridget mentioned, who else is keeping an eye on where the money is going? What's the money trail? Who's following the money?
Yeah. I would say, show me yours before I show you the money. The banks themselves have their own obligation, which in the US, it's imposed through various provisions grouped together into the Bank Secrecy Act. We also have FATCA. We have various provisions that begin to mandate that anyone in the chain of the money trail has responsibilities as gatekeepers. And those persons that have the ability to help facilitate those transactions, they're being put to the fire. They have skin in the game. They have regulators, prosecutors that are looking after them as well. Anti-money laundering provisions are certainly there. OFAC, dealing with politically exposed persons, all of that is now not just a concern of a company, but it is, primarily front and center for any financial institution that's going to facilitate or will be in the distribution chain of the cash. And ultimately, all of this is going to require, commerce is going to require that liquidity. And so who else is in the mix? You've got a lot more cops on the beat. And those are deputized, private entities, private banks that out of their own self-compliance obligations are required to provide suspicious activity reports. You gotta be a snitch. And I'm not gonna play a song on that one, but I could. So look, it's required by law. And so, you've got to think that those that want to engage in fraud or corruption are increasingly coming up with more and more, difficult to detect tactics, which means, a company, such as yours, Rafael, has to continue to be a step ahead and think through, does something smell in this transaction? And if it does, hit the pause button. Think it through, because I guarantee you, no matter how big that project is, it will not be worth it. And so the one thing I want to leave you with is, lots of cops on the beat. It's not just who you might have expected.
Cool. We're coming up to the time, and I think we need to let the audience have some Q&A moments and Q&A time. But we would be doing a disservice to everyone here if we don't address two final topics. First, I would like to ask Bridget about the National Defense Authorization Act. And that that act had a component amending the FCPA, and I would like you to explain to us, what does it cover?
Sure. So I'll try to do that quickly to leave some time for Q&A. But January 1st, the National Defense Authorization Act was enacted into law, and it's Section 6501 gives the SEC a statutory authority to seek disgorgement, and it's, quote, under any provisions of the federal securities laws, in any action brought in federal court where any person received unjust enrichment as a result of the violation. Now, the law doesn't define disgorgement, which is interesting, and it extends from 5 years to 10 years from the latest date on which a violation that gives rise to the claim occurs, the period in which the SEC may bring disgorgement claims for violations under various of the securities laws, 10B of the Exchange Act and others. Essentially, the provisions of the securities laws for which you have to establish scienter. So that's really what we're talking about. And the legislation was in part a response to the two recent Supreme Court cases. There was Kokesh versus SEC in 2017, or some of you may remember, where the court said the SEC's disgorgement remedy was a quote, penalty, and subject to the 5-year statute of limitations. And last year's decision in lieu of the SEC, where the court upheld the SEC's ability to obtain disgorgement as a form of equitable relief under Section 21D5, as long as the award does not exceed a wrongdoer's net profits and is awarded for victims. So I think we're going to see a lot of, there's a lot more detail. We're going to see some upcoming challenges to this, with this new authority, longer limitations period, maybe more aggressive enforcement, longer investigations. It's certainly going to be particularly significant to individuals in FCPA matters, SEC FCPA matters. Because, one thing to keep in mind is that for purposes of calculating the statute of limitations period for disgorgement and equitable relief, any time in which a person against which there's a claim, is outside of the United States, does not count towards the accrual of that period. So the statute of limitations will be automatically told for persons while they remain outside the United States, right? So that's going to be interesting, and there's a lot of other little things that I think are going to have an impact. But it's just enacted, and so we're a month or so in, so we'll see.
Thank you, Bridget. The second topic that I want to ask the three of you is what is your feel for corruption in post-COVID world? We are all locked up, and passing a 50 under the table is not as easy as it used to be.
Let me try to answer that. We've seen, after every crisis, there's always going to be a corruption crisis. We've seen cases like the Hurricane Katrina, Puerto Rico, and the hurricane in Puerto Rico. So basically, what we're going to see after this crisis hopefully is over, the pandemic, we're going to see a pandemic of corruption. And for Latin America, I think there's going to be a lot of with the Biden administration, with the geopolitical aspects in Latin America, with Russia and China playing in the U.S. Backyard, and trying to create more influence. It's going to be, hopefully after COVID, not hopefully, but I believe it's going to be a very busy year, and we're going to see a lot of investigations rising. In my opinion, there are two countries to watch in a post-Lava Jato world: Colombia and Peru, mainly because those are two countries that, you know, have the same political and economic, you know, I'm going to say policies of friendship than the U.S. So they will, you know, try to save those countries. They have both free trade agreements with the U.S., so they're going to have to save them from bad influences, I guess.
Potentially failing too.
I would agree with that, and I think that Rafael, your point is right. That I mean, it may be harder because people are not, you know, face to face, and maybe you can't slip something, you know, the bag of cash. I actually did have a case once that involved a bag of cash, but anyway, that's a whole other story. But you know, you may not have that, but what you do have is it's easier to cut corners when you're not being watched. And, you know, going back to my point about the importance of having that culture of compliance, any culture is harder to maintain when we're not physically present with one another, right? And so even, you know, I'm looking at my law firm, you know, we're talking about how do you keep the culture. Same with any company, and the culture of compliance is one that's important to continue to reinforce that message. And when people aren't there and there's no one around and it's like, well, I can do this, it just, you know, and I'm tired and I, you know, whatever I have to do, and people cut corners. And so I think that there's more opportunity for corruption. The other thing I would say is I think you're going to see it because there's, in fact, I recently did a piece on, you know, World Bank financing. A lot of these institutions are rushing to give out more money due to the pandemic, you know, to try to
easier
help.
Money.
And that's right. And so I think with that will come increased enforcement actions because, as Pablo said, it just, there will be, whenever there's anything that changes the landscape so much, it's just, you know, the opportunity for corruption is there. And thus, I think we'll see, maybe not immediately, but we'll see an uptick in enforcement would be my prediction.
I'll just briefly note that in this, in our current world, more than ever, it is very difficult to hide your tracks. So, you know, when you're not face-to-face delivering the bag of cash that Bridget, I guess, has seen, hiding your tracks, hiding your trail becomes even much more difficult. And, you know, it's a matter of staying away from anything nefarious that may involve, you know, circuitous routes of cash for no apparent reason. I would be very worried about those. You know, if it seems too good to be true, it is. And if it's taking so many detours or routes, be worried about that. And otherwise, I say, you know, let's push forward.
I just want to add something there. Now we're not going to deal with cash; we're going to deal with bitcoins, which is a different issue. And you know, it creates you know, a complete you know,
different set of problems.
And we probably have to address that in the next webinar.
Well, let's open it up for some questions, and the audience can either use the chat, or I think there's a raise your hand option if it's I don't know if that's possible, but feel free to jump in if you can.
So either we did a great job.
Yeah, no question. No questions so far. Or people are shy.
Or they're shy.
Yeah. All right.
Yeah.
Well, thank you, everyone. I just want to make sure that everybody knows the Houston Bar Association International Law Section will continue to trend with Latin America and look at what is called the US's backyard. And we will continue to talk about Latin America next month with a panel, a very interesting panel, Antitrust in Latin America, which we expect will also be very well attended as this one. Aside from that, thank you to the panelists. I mean, all of you have been great. Thank you so much for agreeing to do this and for the time that you have devoted. And thank you to CPAN and Beck and Redden for hosting the Zoom and helping us with the technical issues. Anyway, thank you. Have a great afternoon, everyone. Bye-bye.
Adios.
Well,
Ciao.
I know.
Bye.